Good morning. Welcome to the third of Brodie's Construction Spring Seminars. My name's David Arnott and I'm a partner in our contentious construction team, and I'm joined by my colleague Stuart Murray, a partner in our projects team. Today's seminar is a bit more niche than the first couple we've done, restricted to the PFI PPP market, and it covers the handback arrangements and obligations under these types of projects, which we will see in effect over the next few years. I'll now pass over to Stuart, who'll take us through the first half of this morning's session.
Great, thanks David. Morning everyone. As David says, this is slightly more niche than the other construction stuff, but hopefully everybody that's on the session this morning has an interest at least in PPP projects and handback. So what we're going to talk through is a bit of background, why we're talking about it. We're going to talk about why handback's important, which should be fairly evident by now, but we'll get through that. We're going to talk a little bit about the importance of management and in particular knowledge of projects. We're going to talk about the implementation of handback, and then I thought it would be helpful to run through a couple of talking points on net zero, because SFT issued a paper 2 days ago on the impact of the net zero agenda, in particular in the PPP space in Scotland. So we're going to run through a couple of the points that SFT flagged in that. And then David will talk us through the nitty-gritty bits of where things might go wrong and all of this. I'll talk about the flowery bits and David will talk about the hard bits. So bit of background then, public-private partnerships, or PPPs as we call them, in the form of PFI and its brothers and sisters, for example, LIFT, NPD, HUB and PFI are major parts of the infrastructure landscape in the UK. There's 700 PFI projects currently operating across the UK, and 200 of those will expire over the next 10 years. So that raises questions about how the handback of those projects is going to roll out. When the contracts expire, in most cases, the assets will be handed back to contracting authorities. So some of the early projects contain options to extend, and some oblige the public sector to buy back the asset at market or residual value. Whilst most formal handback provisions in PPP contracts commence around 2 years prior to expiry, the Infrastructure and Projects Authority estimates that it takes around 7 years to repair, and we call that the sort of long handback horizon. It's not a contractual horizon, it's just when you need to start thinking about it. And that's kind of around now for a lot of projects. That action will take place on a playing field which is often uneven. It's easy to assume conditions will favour the private sector investors, which have largely sought to aggregate projects, allowing them to manage contracts on a portfolio basis. And contracting authorities might only have one PPP contract, and the teams which put those contracts in place may long since have departed, although some of them haven't, much to their chagrin. And that might leave some contracting authorities exposed to potentially higher risks. The process of handing back assets after 25 years of operation and maintenance by the private sector is governed by the project agreement. And despite the relevant standardisation of PPP contracts, many of the handback provisions differ in level of detail and process, which means that one size fits all doesn't work. So you can see that we need to talk a little bit about why it's important to get handback right and realising the value for money which underpins these contracts and the procurement of them in the first instance. Given the importance of the underlying services being delivered by these projects, it's essential that the process of handing them back from the private sector to the public sector is effectively managed. Without proper management, contracting authorities may face operational disruption, lack of service continuity, there might be financial loss, and there might be reputational damage. It's really important to get this right. And it's really important for both parties. For contracting authorities, getting an asset back in a condition which is commensurate with the terms of the contract that they signed 2 decades ago is essential to avoid disruption to key public services such as schools and hospitals or services. And it's also essential for them to bake in the value for money upon which the contracts were built. Successful handback can be translated into the public sector getting back what they've paid for over the last 25 years. And that's what these contracts are designed to achieve. For the private sector, successful handback could be the vindication that the sector's been grasping for. Smooth handover of good assets could fuel discussions about possibly the next phase of PPPs, possibly extended services. And given the private sector has the ability itself to take the heat out of discussions from an early stage, smooth handover could be in the private sector's gift. So how do we do that? We talk about management and knowledge. Handback is not a distant event. One of the Infrastructure and Project Authority's notable recommendations in its paper, which is called Preparing for PFI Contract Expiry, is that the expiry process itself should be treated like a distinct project, a project in its own right, to give greater clarity and structure to the process. And likewise, the IPA highlights the importance of early support and buy-in from senior figures within the contracting authority. Having strong leadership and a distinct project structure specifically for Handback is crucial to success. In reality, private sector partners are investing in PPP teams as Handback specialists. They're pulling together industry experts to deliver program-wide, consistent approaches across their investor portfolios. In the public sector, we're seeing steering groups being put together with input required from each relevant department and with senior officers leading the charge. And that's really good to see at this point. Given the complexity of the process, the IPA recommends that early consideration is given to those resources available to contracting authorities and whether specialist advisors like technical, legal and financial people will be needed. They will. Linked to this is the recommendation that contracting authorities speak to and network with each other, and we're seeing that a lot. By collaborating on their experiences and sharing issues and solutions, contracting authorities can better prepare for their own projects. In the private sector, as I've said, equity investors often own and operate portfolios of projects via their management services agreements, and they're quite often grouped by procurement routes. So you might find that there will be a lift department and there might be an NPD department. I'm not sure there's enough of that to get to the critical mass. But it's clear that there will be advantages in sharing information on best practice with internal corporate groups, and early advancement along the learning curve will bring sharp focus to the requirement for contracting authorities to put in place management processes and structures. The people that get there first, who do it first, and then apply the learning of that first experience into their next projects will be the ones that know how to do this best. So let's talk about doing it and implementing it. Implementation, as we all know, is a process, it's not an event. Successful implementation is necessary to ensure that transition doesn't impact on the quality of the services, and that's key. The IPA breaks down the implementation process into 5 different topics. So the first of those is contract awareness and management, contract management. And you might not be surprised to know that this is a drum that I bang quite often when speaking to clients, which is that you need to have a solid understanding of the contract to provide a foundation upon which the whole process is built. You wouldn't believe the amount of times where we speak to clients and say, could you send me the contract? And we get the contract as it was signed 20 years ago and nothing else. Awareness of, and by nothing else, I mean all the variations that have happened since. Awareness of the expiry process provisions in the contract is essential. Those provisions are not always clear and they're not always prescriptive, and therefore an early understanding of the contractual backdrop is important. The handback provisions are also rarely identical from one project to the next, as I've said. They will broadly consist of a requirement to survey the assets, prepare a plan to ensure that the assets meet the handback requirements, which are often simply expressed as the assets requiring to comply with the condition required by the contract generally, which is not very helpful 25 years later. You then need to carry out the work, have them signed off, and consider how they'll be funded. Often by the time handback works are considered and agreed, the senior debt will be repaid, and there will either be a reserving from the unitary charge required or the option to put a handback bond in place, and the bonds are things that we've seen in the more modern contracts. All of those things have to be considered in the round when you're thinking about contract awareness and management. We've touched on it a couple of times already, but relationship management is definitely key here. Given the complex web of each of the parties' obligations, having a good relationship between stakeholders is essential. Building and maintaining this relationship will make implementation more efficient. And like all effective relationships, they will take time to bed in and develop in the context of expiry and handback, particularly where parties are starting from a less than harmonious operational foundation. It's a different relationship that you need to move in. It's not day-to-day operations, it's how do we get to the end of this? What do we need to do? We need to do different things. How will we have those discussions? In our experience, that team does consist of the people that have been on the ground managing the day-to-day operations of the project. But people might also try and parachute in the handback specialists from the private sector, the senior officers who might have had little day-to-day interface with the contracts. And in public authorities, if you think about in Scotland, we've just gone through local authority elections, you do get changes of personnel. That means you have a requirement to speak to senior people or elected members about projects that you think everybody knows everything about. You have to re-educate them, you have to tell them what's happening, and then you have to tell them it's coming to an end. And that can be difficult. The third thing that we need to think about is the asset itself. Underpinning the whole expiry process is the handback of the underlying asset to the contracting authority. And the condition of that asset at expiry is key to continuation of service, and a clear understanding of those assets shared between the parties, and crucially in the context of the contractual requirements in respect of those assets, is vital. A lot of the government agencies talk about parties having commercial approaches to handback, and contracting authorities need to assess, develop and confirm their aims and objectives from the outset and be open and honest about those objectives in order to provide structure and focus to the decisions that they're making during the handback process. The IPA and the SFT also highlight the importance of recognising if there are commercial levers available to the contracting authorities, and both parties need to think about that. And the final thing that we need to have a think about is the future of the service. The handback process presents an opportunity to set out how the future of the service delivery will work. It's important that the process helps facilitate the delivery of continued and/or new services. The IPA guidance document should be read by all stakeholders involved in the expiry process. It gives you good ideas, good tools. And whilst it doesn't provide project-specific advice, the underlying themes and guidance provide a framework from which all parties can begin preparation and guide them throughout the implementation phase. I mentioned at the top that we would talk a little bit about net zero, and that kind of brings in future proofing of these assets as well. And I thought it would be helpful to discuss that in the context of PPP handback particularly, because SFT published its paper called Guidance on Pathways to Net Zero for Assets Delivered under PPP Contracts. It's a bit of a mouthful, on Tuesday this week. So we all know about Scotland's 2045 net zero emissions target. That, as Kerry Alexander from SFT commented earlier this week, doesn't discriminate between buildings procured under different contracts. And PPP participants are beginning to review how PPP assets, which are traditionally viewed as fairly inflexible or costly when it comes to change, will have to form part of the pathway to net zero. They form a huge part of the public building space that we have in the country. As I said at the top of the chat, where there's 700 projects involved. We can't ignore them. We've seen some of the work around the edges being done already on parts of the PPP estate as the public sector kind of grapples and gets to grips with its own individual net zero targets. They're quite often not the same as the Scottish Government targets. And examples of that might be the addition of LED lighting or solar panels, which are kind of bolt-on bits around the edge. They're really window dressing, and they're not addressing the big issues. The SFT note that investment in net zero compatible heat sources will be required for every building. The question in relation to PPP assets is when the authority chooses to programme these sorts of improvements in the context of the project. And of particular importance to this morning's topics, how that programme and that programming will interact with handback and that long handback horizon, that 7-year soft landing period. We've talked about it up to this point, but in essence, handing back what has been paid for. The net zero discussion brings in some interesting complications regarding the useful residual life of elements of the asset which were not built during the original construction phase and may have been added by variation. This is not a new concept. Few PPP assets escape the wonderful complexities of major variations throughout their lifetime. And that in itself can be a major headache when embarking on the handback journey, nailing down exactly what is and what is not part of the project. And that process requires careful diligence. And that is when the long hours of administration and record keeping really become champions of the project. If you can't pull together an accurate picture of what the project actually is, as varied over its lifetime, figuring out what needs to be handed back and in what condition can be a fairly thankless task. However, the 2045 net zero targets collide with this already complex space. It forces the authorities to think about modifying assets at a time when steady state operation in preparation for handback is key and is at the front of everyone's mind. Bolting on additional energy saving major variations to projects which are fast approaching their expiry will not be easy. The bolt-on elements might have to sit outside the four walls of the contract, and then you get into the web of complex building system interdependencies, and that will all be brought really sharply into focus for everyone involved. SFT highlight key areas for discussion here being early consideration of the project risk profile, and the need to maintain project return. We can't forget that in all of this. Maintaining the integrity of the buildings if new energy systems are installed, that's the complex web of interdependencies I was talking about earlier. We need to think about the FM provider's ability to deliver the service and remain risk neutral following any addition that we make to get to net zero. We need to understand the due diligence and the cost of doing it and the practical implications of change under the contract. They all have their own change procedures. They all have their own little variances, and it's all really good fun. Layered over all of that as ever are procurement considerations for the authority. They're not insurmountable, but they're not insignificant either. And we need to think about that carefully when we're thinking about any of this stuff. The SFT identify 5 stages in a catchy continual revelation of decarbonisation options until net zero is achieved. This is their format for iteratively getting to net zero effectively. If you look at the paper, you'll see there's a lovely graphic with a big tube and lots of little dots. It's lovely. But the 5 stages of interest are determining net zero roadmaps and targets, assessing baseline energy and carbon performance, decarbonisation options, net zero business case and investment models, and implementation, measurement and verification. And the last 2 of those stages will, in all likelihood, be taking place against the backdrop of projects hitting that 7-year long-term handback horizon. Indeed, stage 5 is likely to have to travel much further down the road with the project in the rearview mirror. Stage 4 will require identification of life cycle, PPM and handback for projects and implementation, as well as having to carry out energy conservation option appraisals and ultimately result in the agreement of an asset or a procedure change. And stage 5 needs works. And we all know by now that works in an operational PPP project aren't as straightforward as D&B works on a plain vanilla job. They just aren't. We need to think about opportunities in all of this, and the SFT paper highlights that really clearly for us. Most of the projects out there will require some semblance of like-for-like replacement for major systems prior to handback. On strong projects, the maintenance regime will have been good enough to avoid having to replace big bits of kit through life cycle up to this point. But many of the projects will land at that point right at the beginning of the long-term handback horizon, possibly closer to 5 years prior to expiry. And the relationship between the need for like-for-like replacement in accordance with the contract and future-proofing of a building and getting it to net zero in the near term creates another challenge for those involved in handback. But where there's challenge, there's often opportunity. We can see how an SFT flagged this as well. With a small change to specs, room may be created for alternative technologies to be implemented in a project. For example, with the replacement of an old boiler with a ground source heat pump system instead of a like-for-like oil boiler, sticking in a ground source heat pump system there gives you that net zero. That change will need to be paid for, but combining value for money with net zero requirements, it shouldn't be too much of a stretch for authorities to get into a space where this is possible. And whilst they're at it, they could also be adding data points needed to ensure building performance in its new net zero world so that it can be monitored I've spoken in the past about the future of infrastructure assets and the relationship between the reuse, refurbish, net zero agenda and the building performance data points that will be needed to manage that old new world. We've seen firsthand how collaborative PPP teams can approach these discussions with creativity, provided that all parties are at the table, understand the rules of engagement, and work within that wonderful phrase of the art of the possible. PPP projects are not one-sided affairs. They create decades-long relationships between the public and private sector, and to make a success of them, we know that collaboration is vital. Successful handback and the ability to realise opportunities presented by this junction in the road cannot be done by the authority alone. It'll need funders, project companies, management service providers, FM service providers to come together with a common understanding of a common goal. And it'll definitely also need some lawyers to figure out how to contractually implement the groundbreaking solutions that the project teams will no doubt come up with. And that was my sales pitch, in case you missed it. Our experience of working with and talking to private sector partners is that they're keen to help. They've got the skills and the vision to implement these difficult changes if they're supported by the authorities to do so. And I suspect if they're successful, the relationship between service provider and authority may have a chance of avoiding expiry when the project agreement is long gone. And with that positive note, I'll hand over to David, who will talk about the problems.
Thanks very much, Stuart. I now want to take a look at some of the key areas where I see potential handback disputes arising. Given that none of these projects have gone through handback yet, then this is just my views based on, firstly, the normal contract terms we see under these types of project, and secondly, the types of disputes we've seen arising on such projects through the concession period. First off, I think we should be in no doubt that there is a significant prospect of disputes arising. That will most likely be in relation to the condition of the assets being handed back. But why is that? Well, there's a number of key factors here. Firstly, there's potentially large sums at issue. PFI assets, by their very nature, are generally significant projects and also very expensive assets. They're constructed and maintained using a very complex suite of contracts, a number of which have detailed provisions regarding the condition of those assets generally, and in particular deal with issues such as defects during construction, maintenance, life cycle, and handback, which we're focusing on this morning. The interaction between these various provisions is not always straightforward, and I think that's going to be an issue we see more about as we move into handback on projects. The other factor here is there's a number of interested parties included in the project, and all of these parties generally have different obligations and responsibilities regarding both the creation and the maintenance of those particular assets. So again, the more parties you have, the more it complicates things, the more likely it gives rise to disputes. Along with the fact there's a multitude of parties in here, there's also an inherent conflict of interest between the parties. At authority level, you have an organisation that has paid for the asset, it's paid for it over 25 or 30 years through the unitary charge, and it obviously wants that asset back in the best condition possible. If it doesn't get it back in that condition, it may have issues going forward with regard to having to carry out remedials, with regard to enhanced maintenance, and obviously it wants to avoid paying for that because it's already paid for it through the PFI project. Against that, you have the conflict of Project Co and the contractors, who obviously want at the end of a project to minimise their expenditure when they're handing it back and maximise the return on the project. So that conflict potentially will cause disputes to arise as well. And also, what's been a 30-year relationship is possibly coming to an end. So the issue of trying to work together may not be as much of an issue going forward. The other issue is just over that particular time limit. These contracts have been in place for 20 to 30 years, and that in itself brings in a number of challenges or issues which might increase the prospect of disputes arising. First off, the drafting in many of the early projects was not particularly sophisticated, if it existed at all, in relation to handback. We have a lot of bespoke drafting in the PFI PPP suite of documents, most of which has not yet been tested, in respect that we have little by way of court authority on how you interpret these provisions, and certainly in relation to handback, no practical examples at the moment to see how it's actually going to work in practice. So there's no way of really, or there's no guidance there particularly at the moment. The other big one, which we don't normally see in construction projects, is because these projects have been in place for so long, standards will have changed, and the law has changed enormously since these projects were first conceived. And the consequence of that for handback is the standards to which you have to hand it back may already be redundant, that in itself causing other issues. Stuart's already mentioned that over the concession period, there may have been a number of variations altering the asset, and that obviously also has to be taken into account. And, unlike, normal construction projects can have a huge number of variations, but with PFI and PPP projects, over that period, there can have been many more, and they can have a much more fundamental impact. And then just from a practical point of view, records are crucial. Stuart has mentioned that the terms of the contract are crucial. We're now going back to documents that were created 25, 30 years ago, and it remains to be seen how good the records will be, particularly in relation to variations over the period. And also the people who were involved at the time these contracts were in place, many of them will moved on to other jobs or retired. So tracking down people who knew anything about it will be much more difficult. And lastly, just with the passage of time, issues around time bar and prescription will become much more important as well. So I just want to look at a few of those in a bit more detail. So firstly, the handback process itself. As I've mentioned, there was really no provisions in the early contracts. So what we're going to do with those contracts is, where issues arise regarding the state of the asset, we'll just have to look at the provisions that apply in relation to construction and defects, FM obligations and life cycle obligations, to see if they have any provisions which might assist the authority in terms of handback. As PFI and PPP moved on, the processes became more involved in the contracts, and we now have a more standard position. Broadly, how that operates is that there will be a survey of assets, and that survey should identify handback requirements. As Stuart mentioned, that normally happens about 2 years before the end of the concession period. Once the handback requirements have been identified, then there's often an ability for the authority to retain an estimated cost of carrying out the rectification works until Project Co has carried out those works. Project Co then proceeds to carry out the works, or the contractors down the chain do, and at that point there is a release of retention if the works have been carried out, or if the works haven't been carried out, then the authority can carry the works out itself and make a deduction from the retention. And we might also see agreements reached whereby works aren't carried out and the authority just takes a deduction, particularly in circumstances where things may need to be altered anyhow because of changes in standards or regulations. I suppose the takeaway on this is it's absolutely vital in all projects that you check whether you have a handback mechanism, and secondly, if you do have it, exactly what that mechanism provides in terms of the obligations on the parties, the procedures to be followed, and the timescales within which that's all to be done. So where are the main areas for dispute? Well, the first one that strikes me is, what are the assets? Now, you would think that should be obvious, but alas, we can foresee issues in that particular area. First off, just in relation to the contract and the technical standards that apply, is there a complete copy of the contract? as I've said earlier, it may have been 25 years, 30 years ago that that was put in place. Does it adequately describe all the assets that have to be handed back to the authority? That obviously is the starting point. Secondly, many of the PPP projects had review procedures at the outset of the contract, because things may have not been completely nailed down on day one when the contract was signed, and therefore what was the scope of the assets that was agreed through that particular procedure. Good example of that is FF&E and schools projects and hospital projects. We've seen numerous disputes throughout the concession period about what had to be provided by way of FF&E at the outset, never mind what had to be handed back. So I do foresee a lot of issues around those sorts of aspects. And lastly, again, variations, which we've already mentioned. Works may have been omitted, works may have been added. Is that all clearly documented, and has it been documented in relation to what is to happen at Handback, where there have been such additions or omissions? Assuming you can, however, identify the assets clearly, the next issue becomes, what are the handover standards? Now, again, the starting point is the contract and the technical standards. And the issue here is, does the contract set out clearly what the handover requirements will be? In most cases, it should do. This can be done in two ways. First off, you might see very specific standards that apply. For example, it may be reference to building regulations, it may be to industry guidance and policy notes. If that's the case, are these specific criteria clear? Did they actually get met when the buildings were constructed or the assets were constructed? What happens if specific standards have been updated? Do the updated ones have to be met at handover, or only the original ones? Similarly, we may have very generic standards or general standards. The issue then will become, what do they mean? What were the standards at the time of construction? You know, if it's something like built to using good practice at the time, what was good practice in 1998, 1999, that will all need looked at. And again, if these practices have changed, what is the impact of that where you have generic standards being applied? I have a dispute at the moment. It's not a Handback one, but it's a deductions one. It's a 16-year-old project. And the dispute in that one is, what were the standards for building a care facility in 2006? And it raises quite difficult issues when you're having to go back that length of time and look at what the standards were at the time. So I foresee those all being particular issues. I just, sorry, very quickly on this one, the last one, just again, variations. As I've said, variations may have impacted on assets and the ability to meet handback obligations. For example, we know of and been involved in projects where some of the maintenance obligations may have been removed to try and bring down the unitary charge, particularly at the time of benchmarking. If you've taken the maintenance obligations out and they impact on the asset, how does that affect the handback obligations? The next issue is, assuming we've got the asset and we've got the standards, do the assets actually meet those particular standards? If the standards are not clear, then we will definitely have disputes. But even if the standards are clear, there's still room for dispute. For example, if you have a performance standard rather than a physical standard, so if it's something, for example, that rooms have to be maintained to a particular temperature, and there is an obvious defect, such as the fact that the central heating in a room is broken, that may not necessarily be a breach of this performance standard. If a lot of the projects, and we've had disputes on this, where you have a requirement to keep the room at a particular temperature, the central heating can be broken and you could still always be in the temperatures range that's been set. So what you need at Handback as the authority is much more than just a survey and a list of defects. You need to then identify whether those defects cause a breach of the actual handback standards. And I see quite a bit of scope for those sorts of disputes arising, because we've seen them arising quite a lot during deductions disputes in recent years. Defect surveys have been carried out, defects lists have been produced, but they haven't then been tied back to the standards required under the contract. And again, just variations crops up again. Same point, what if they've caused the inability to hit the handback criteria? For example, if you've introduced a variation whereby additional kit has been put in, for example, that may impact on the lifespan of generators and whether those generators are able to meet the handback obligations. Another area which will be ripe for dispute, if standards are not met, then Project Co is likely to have a liability, but then who is responsible downstream? This may lead to results under the FM agreement, the design and build contract, and the interface agreement as to who is liable. One issue around that is, have the obligations and standards that were imposed on Project Co been properly passed down to the subcontract chain? And are there any disputes? If there are, any gaps? If there are gaps, then that will increase the possibility of disputes again. Another thing that complicates the handback obligations is the interaction between the handback obligations and the interaction with the other provisions which regulate the condition of assets. So for example, if something doesn't meet its handback obligations because of an inherent defect when it was constructed, what's the responsibility for that? How do the provisions regarding construction and dealing with defects sit with the handback obligations? Similarly, if it's a lack of maintenance, either planned preventative maintenance or reactive maintenance, how do those provisions react with the handback obligations? And lastly, life cycle. Again, was that something that was to be carried out by the FM contractor or Project Co? So where we might get to is that the cause of a particular problem is clear, but who's to fix it is not clear. And we have seen these sorts of issues rising very regularly in performance deduction disputes again. So obviously the authority might have a dispute with Project Co about deductions and who's responsible for those deductions. But what we've also seen is that can lead to disputes between Project Co and the D&B contractor or the FM contractor. If it's an inherent defect and the design and build contractor built it, for example, he may have to fix it, he may not. There may be obligations on the FM contractor to fix it and then try and recover from the D&B contractor under the interface agreement. But we've also seen situations where the authority itself has warranted to the FM contractor that the works would be built in accordance with a project agreement. So all these sorts of things complicate who might be liable, even if things don't meet the handback obligations. And I think we will see those sorts of issues that have arisen and deductions will arise in relation to handback. And I guess around that, it's one thing for the authority to think about, does it just deal with issues through the handback obligations, or does it look to deal with it through other mechanisms, whether that be around defects, performance deductions, or life cycle? It does have other options there to look at possibly before you get into handback. Just a few other points of relevance I wanted to mention quickly. I can see disputes arising in relation to the estimated cost of rectification and the retention that authorities try and hold off or hold back from Project Co. I can see disputes about whether work has actually been carried out correctly to meet the handback obligations at the end of the job and whether that has been completed. I mentioned prescription and limitation. I won't say too much more on that because it was mentioned at the outset, but suffice to say that will be an issue, and the critical issue will be if handback obligations are not met, what was that caused by, and when did that particular breach occur? And is there new obligations put onto the parties at the time of handback? So these will all need considered against the background of prescription if it's a Scottish project, or limitation if it's an English project. And I'm sure a lot of you will have heard that prescription is an area of the law which has been up in the air for the last 5 or 6 years. We did have new legislation or amendment to the legislation in Scotland at the start of June, and hopefully that will give us some clarity over the position moving forward. On a similar vein, one needs to consider contractual cut-offs, because it is quite common in PFI and PPP projects to see some cut-offs of liability. For example, the design and build contractor often gets a cut-off of liability after 12 years. So these points also need considered in relation to handback. And lastly, just very quickly, the DRP process, check what it says if you are getting disputes, because the early mechanisms were not as sophisticated and do have quite a number of flaws. So it's easy to get into trouble just with the dispute resolution provisions, never mind the underlying substantive dispute. And then very lastly, what sort of mitigation measures can be taken to avoid disputes? Well, keep clear records. That's obvious, I guess. That's in relation to the contract, the technical documents, the review process, and also the variation history. Clear records should be kept of all of those. I may be recommending shutting the stable door after the horse is bolted there, but you should certainly gather everything you can in that regard. Review the handback process well in advance. You are going to have very compressed activity at the end of the project, so there's not going to be a lot of time. So think about this as early as possible. Considering agreeing a process for handback, try and agree how you will do the survey, try and agree the standards you are going to apply, and also consider whether you want an independent certifier or party to assist you, both in relation to carrying out the survey, listing the works to be carried out, and signing off after the works have been carried out. Consider the practicalities of the work, when best to do it, is it worth doing at all? Is a commercial settlement more sensible in the circumstances? And lastly, for the individual parties, for the authority, look at your other options. I've already mentioned, look at your options under the project agreement for defects, for deductions, for life cycle. You may want to use those long before you get into handback. For project co, the big things probably look at the position downstream and protect your position. Do you need to take any steps to ensure your D&B contractor or FM contractor are doing what they're meant to? Are you making sure you preserve claims under those contracts if you need to? And I guess for the downstream team, maintain clear records to prove you have complied with your obligations. So for example, for the FM contractor, have you got clear maintenance records to show you've done all the planned preventative maintenance? Do you have clear life cycle records if you've had to do life cycle works? And that's just to minimize the risk of claims against you at the end of the project. And that was all I had to say on that at the moment. We've kind of bumped up against our 9:15 end time. We've got a couple of questions, but given the time, I think we'll follow up with those separately after the event. For now, just as is on the screen, a quick reminder that the last of our spring seminars is on the 21st of June, and it's the resurgence of construction management, and you can register for that on our website as normal. The link is on the screen. But for now, thank you very much for your time and attending this morning, and I hope it was of some benefit. Thank you.
Thanks, everyone.